Did you know the distinction between a public trust and a private trust? If not, read this blog to understand the differences between the two. There is a severe notion among people of the elite sector of society who can produce trust. However, that's not true. Trust will be created not simply by high net worth people, but by standard men and women. The provisions of the Indian Trust Act of 1882, referred to as the Act during this article, govern only private trusts. Somebody can separate trusts into two kinds: charitable trust and personal trust. They're not as similar as some assume them to be. Definition of a trust. Trust is outlined in Section 3 of the Indian Trust Registration Act, 1882, as an obligation annexed to the possession of the property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him, for the advantage of another or of another and also the owner. In other words, it's merely a transfer of property by one person, the settlor, to a different, the trustee, who manages that property for the benefit of somebody else, the beneficiary. The settlor should de jure transfer ownership of the assets to the trustee of the trust. In India, trust is the second hottest style of registration. Who will produce a trust? A trust conjointly is created by all and sundry who are competent to contracts. This includes an individual, AOP, or HUF company. Suppose a trust is to be created on behalf of a minor. In that case, the permission of a principal civil court of original jurisdiction is required. Further, it also depends on the law in effect that prevailing at that individual purpose of your time, and also the extent to which the author of the trust could dispose of his property. What's a private trust? A private trust may be a trust established for the advantage of a person's people and are enforceable by the beneficiaries. This trust is typically designated for family, members, relatives, and friends. One of the options of personal trusts is that they should have actual beneficiaries. Furthermore, the creation of a private trust offers dealings a legal kind. It ensures that assets or property are employed just for the benefit of appointed beneficiaries, and the trustee needs it to be handled within the approach. Kinds of non-public trust, voidable trust. It's another to will. It doesn't defend any quality, as they will be withdrawn from this trust. Irrevocable, non-discretionary trust. Assets can't be withdrawn here. The settlor has complete management over trust norms, as he can decide which beneficiary receives which asset and what proportion. Irrevocable trust. During this case, settlor lets the trustee decide which beneficiary gets which asset and what proportion. The settlor solely decides beneficiaries. In different words, whereas the beneficiaries are identified, their applicable interest within the trust isn't observed up front. Public trust. Public trust is created for public charitable purposes. There's no all-India level act for fitting public philanthropic trusts. Many states in India have enacted the General Public Trust Act. In contrast, most states in India don't have a trust act. An NGO can be created solely below a public trust act. What's the distinction between a public trust and a private trust? A public trust may be a trust for a public entity. It's an involuntary trust meant for non-secular and charitable purposes. However, the entity or society should be a registered society entity to be listed as a beneficiary. A personal trust is wherever the beneficiaries are definite people. You'll be able to name anyone to be your will's trustee or trust. The beneficiaries are often individuals and people. It is your family and relatives, or it can be a shut friend. The foremost vital distinction between a trust and personal trust is that in publicly trust, the beneficiaries are uncertain, not notable, and massive in number. Whereas within the case of a private trust, the beneficiaries are sure and known, similar to relatives, friends, or family of the author of the trust. A trust is open for inspection. Individuals will question the small print of its trustee's management and purpose. Since it's a public trust, special care is taken to ensure transparency, effectiveness, and utility don't seem to be diminished and incessantly serve the beneficiaries as intended. Personal trust is supposed for the private eye. Solely lawyers and beneficiaries can view it beside the will's owner. If anyone not concerning the deceased wants to look at it, they won't be in a position. There's a distinction between the purpose of a personal trust that's for the advantage of a particular cluster of individuals or persons, similar to a spouse, children, relatives, or alternative beneficiaries, and a trust during which the settler has discovered for the